Court officer? Hello, court officer?
Yes, ಹೇಳಿ sir.
ವಿಡಿಯೋ ಬರ್ತಾ ಇಲ್ಲ, ಆಡಿಯೋ ಏನೋ ಸರಿ ಹೋಯ್ತು.
ವಿಡಿಯೋ ಬರುತ್ತೆ ಸರ್, ಒಂದು ಸ್ಟಾರ್ಟ್ ಆದ ತಕ್ಷಣ ಬರುತ್ತೆ ಸರ್.
ಆಗ್ಲಮ್ಮ, ಥ್ಯಾಂಕ್ ಯು. Court officer? Court officer? कोर्ट ऑफिसर.
Yes, sir. ಇನ್ನ ಶುರು ಆಗಿಲ್ಲ ಸರ್.
Okay.
మనం మాట్లాడదాం.
Court officer? Court officer?
ಬರ್ತಾರೆ ಸರ್ ಬರ್ತಾರೆ.
ಸರಿ ಮೇಡಮ್.
Number 16, yes. Oh. The witness of submitted to the land council that is not well, causes matter.
Six, my lord. Serial number 46.
This call 17. No, call in the line.
Well, serial number 23, my lord. Sorry,
Yes.
19. Sorry, serial number 19, my lord. ಅದರಲ್ಲಿ ಈಗ in Sripad V Shastri name may be deleted. Kalpana PV is appearing. Serial number 19.
Of Sripad V Shastri in item 19. Yes, sir.
For 46 ತಗೊಳ್ಳಿ. 46 next week. I am not in a position to do today. 46.
What is it? The request of the account for that next week? Yes.
Much obliged.
Yes. Could you find it at Edu Sambhaji Shinde Supreme Court judgment. I think it's Edu Sambhaji Shinde. That's the name of the. That's there. She'll get it. Just we'll take up the next matter. Okay. Next matter. No password after this call. After next matter we'll call. After get that judgment.
Serial number 2, I appear for the respondent number 1, my lord.
You appear for the appellant? Then where is the appellant? Let's see what is the matter about. Yeah. Oh. Owners of oh.
First reminded that.
Oh.
Thereafter, where we after recording the evidence, just come to conclusion that what that
You're satisfied. And what is this appeal?
that's part that's what the once the matter. The order being demanded that. We are satisfied that he is agreed with that he has to challenge that not this.
The matter is posted as there was no representation on behalf of the On 14/9/2023, the matter was directed to be posted for dismissal on 19/9. Again on 19/9 also there is no representation. Today also the matter, though matter is listed under the capital decision, there is no representation on behalf of the applicant. This is for our prosecution. Yes, next. Next. They got the judgment. Once the judgment is, then you call that one. Yes,
Asarani, serial number 3.
Aksha Devi.
Serial number 6, I am for the
Please,
appellant.
serial number 3. Where is Mr. Ravi F. Sampati? For the respondent.
Otherwise, one IA is there, my lord, for withdrawal of the amount.
No, you are not there in this matter, item number 3.
Yes, my lord. I am sorry.
Yes, next.
Serial number 6.
Narayan Rao.
It's an insurance company's appeal.
Appeal is by insurance company.
You represent? On liability? Fine. What was the claimed amount?
Is it serial number 6, my lord?
Serial number 4, sir.
4.
Oh, it won't be there on the display board. Which matter is going on?
That's phone.
No, in the phone, you can have the display also. Yes. How much is the claimed amount? 30 lakhs. How much was granted? 28 lakhs? 96,000. Case of death? Amputation. What was the age? 16 years. So for that 1.5 lakh, you prefer this appeal? No, their appeal. Let's see, let us you, because it's on quantum, you argue the matter. From where, which para? Let us read from issue number 2 at para 12. No, let's read from para number 12. The petition is a victim and he has claimed. Yes. The injuries are multiple.
Translated over open move BT right up. Operation over the chest, right? Clavicle back. Structure of left shoulder, structure of right knee, structure of right clavicle.
So almost right from top to bottom, he has sustained injuries.
Amputation of right upper
Limb.
these are is not excluded. What we are excluding into the large for an excessively children, that I am
Even in case of an engineering student, around the 10,000, 12,000 is taken, how it is in case of a 10th class student?
Because
Hmm. Correct, but he is a 10th class student. He's a 10th class student.
Then is the report of the grade sheet.
Hmm.
Performance was very good. And moreover, the social problem, we cannot do why we cannot do common man is
Application.
very necessary. Out of in fact, in class of what was taken 18%. So, user process around the very nice room only is.
Because to add the future prospects, as on that day, he is not at all learning anything. Ten, 10th class.
But living into the. Prospects are very. But that is. Even most of community.
No, it's an admitted fact that he's a non-earning member. In that case, what did the Supreme Court, how it was, their income was assessed? When he is not a non-earning member, notionally one has to look at it. Is it not? Notionally, some amount has to be taken. That's not, that 10,000 is not notional income. They have assessed it at then in the other cases, what was the Supreme Court has taken? Kurvan Ansari's case or what? What is that? In Kurvan Ansari's case, how much was taken? 30,000 or?
I believe it will not.
No, that we will see. First on the, let's apply, you tell the court some judgment which is in your favor, will consider it. Kurvan Ansari, it's here. Take the judgment, Kurvan Ansari. No, here the difficulty is, there are judgments to the effect where if he is an engineering graduate, if he is in first year, second year, third year, there was something to expect. Now, because there is every possibility that once you will finish it, you'll get a job, what it would be. Now, in this case, is a non-earning member. In case of a non-earning member, how much we have to take is the question. In Kurvan Ansari, instead of taking the 15,000, court had taken 30,000. That's how it's taken. What do you say, Mr. Broda? He says the court here is taking notional income if it is age of 16 as per the chart they are taking. That's what he is talking. That's how the courts are applying. Is it so? Is it so?
Not taken at it. Then I am aware.
What do you say, Mr. Krishnaswamy? No, in case of a 16 years boy. as fixed by the legal service authority. So whatever is the notion. It's a different, Mr. Guru Prasad was there on that day, elaborate description. Yes. So,
Finally, you're not doing that.
so now, Mr. Krishnaswamy, in this case, he is aged about 16 years. No, court has taken 10,000. So now what will happen is if you apply Kurvan Ansari, drastically the amount will come down because it's per annum, it is 30,000. We'll look at it, definitely we'll look at it and you also want to go through the judgment? So with that year, what was the minimum wages is the first? Shall we pass over this matter so that you can have the judgment and we'll tomorrow? Next week, oppose this matter on Monday at the request of and get the judgment and keep this in this file. Yes. Number one. Where is the judgment? Serial number one. How?
So, consequences which he is supplying various in the.
Please pass on the judgment one. Hmm. Hmm. Hmm.
One
Hmm.
is for the removal of those. It is hereby declared that the death of or bodily injury to any person and damage to any property of a third party. Just
Prasanna. Prasanna. Satish.
The thing of the accident is the omission led to the accident occurred in a public place. The vehicle is public place, part of vehicle to and causes damage to a property and a person. That was the intention. Is staying in a public private place. In fact, commences from the public place, that is nothing really required. Really, of a dozen digital academy meets because the only point that was discussed. All of us agree. It's serious from having is done to a person, but the case of the I was standing in his plate at home. It says must go. And an accident, you were cast in insurance company as you did you can get it at home. At point of time, this explanation is happened again. As one, or omission, get to the accident, occurred in a public.
When you look at the facts of this case, the facts of the present case and the claimant stand on a better footing than this case.
We were a public place, the road, vehicle was taken in a private land. What the complaint is? In fact, to have commenced, to have started in a public place, is not there. The entire accident from A to Z has terminated only in a private. What is to be discussed? But
That according to you, it is it has to be for agriculture use. It was used for a commercial use. Where do the policy? No. Where do the policy says that it should be used only for this purpose, but not for something else?
there is so much very important.
No, what does the policy contain? That we will see once. Give the record, take out the policy. Lower court record is not here. What had happened? You give the code. Did you keep it in there? You have the policy. Okay? Awesome. Hmm. Hypothecation. Oh, right. Insured name. Fired. Eliot. Carlson. Terrorist.
Also, the nominee name is also next page, agricultural don't damage. Quality is a must for all the vehicles, but it's but this doesn't cover the rest of
Other things also, the three and.
Decide get from the system. If you are to debate, accident takes place before. Otherwise, owner is better.
Two, you are on these two issues. Not on the quantum. Not on the quantum. And which provision you are relying on? 140?
Patient. It's a city for insurance. One. Then 147, we get very, the place and activity. One. 49.
140. Settlement by insurance company and
Why do we cover policy? It's not required to be covered policy. Covered in actually this, not taking place. Insurance liability moving property for what is policy. If the insurance has been included.
No, I'm looking at 149. I don't find what you read. Yes, the insurance company shall upon receiving information.
Concerned with clear. Some changes in 151 of amended.
No, where do you get that? It is with effective from today. Settlement by insurance company. It doesn't say so. There is no footnote also.
When it existed.
Give the old act. This is also an old act and new after amendment only. You are relying on 147, 8 and 9. 146. Necessity for insurance against third party. Any other person to use a motorcycle in a public place. Unless there is enforced in the qualified insurance company with the requirement.
One also will be.
It is not end, it is or. It is not end, it is or.
Right. Anything over the. Anything over the.
Let's read the 2 again. 147 Roman 2. Against the death of or bodily injury to any person, to any passenger of a public service vehicle caused by or arising out of the use of the vehicle in a public place. It has to be or and to say what to submit.
use of vehicle,
Is one limb of it.
how is the vehicle? Raising of use of vehicle.
In a public place.
What? Other here, reach
160?
five.
Let's see.
State government may simplification they will be with it also not more without access thanks to the here this chapter refers to for 30 years explained in the for compensation in respect of accidents involving the death of the bodily injury, persons arising out of the use of motor vehicles are damages to any property and property. So arising upon that restriction has to happen only in a public place, intentionally not placed here, because it is a power to ability. Whether an accident takes place in a public or a private place. If it happens in a public place, policy will cover the risk. Otherwise, point is
Of course, that's why the court also is interested.
well, what is other? What is the
Public place means a road, street, way, or other place, whether a thoroughfare or not, to which the public have a right of access. Now, in this case, the driver of the tractor was driving the tractor on a bund where that bund is accessible to all the agriculturists who has to reach their respective places.
the road has because the land. We dashed against but all opportunity when we get to demarcate. Dashed against it. It's not a road. And that is the reason for it's again.
No, it's about, it speaks about a public place definition, road, street, way or other place, whether a thoroughfare or not, to which the public have a right of access. No, if you see in the villages, all the roads, you cannot know the internal roads which are there to reach the respective fields. You can't call that a public road because, it is every person has an access, a right of access to the place to reach its respective land.
Rights. These we will try to understand what it means.
Yes.
Things we ago
Comma.
Street. In cities, we will have this.
Yes.
They is also included. Agricultural land. Also made. They-
Everything.
Basically. Yes. Whether it's above where or where is normally interest. Yeah, place where normally access not be given. All the way. Some people will have an access. Or not. To these, all these things, there is one requirement is
Public should have an access.
have right of access. Utterance. Right of access. The large agricultural land, large zones, we can't claim that I've got a right of access. That's the private. Likewise, any other also. Nobody can claim this lack of right of access. In fact, this is the difference.
Yes.
Settlement or somebody can go in between. There must be a right of access. That is that. That is not.
Now let's come back to the
Even see.
149 to be. So now the provisions you're relying is 145, 146, 147, 140, 140,
1 and 140.
149, 1 and 2. Yes.
What a requirement to cover this.
149, 2. Oh, what is
Both terms shall be paid by an insurer.
it?
Both terms shall be paid by an insurer. The respect of money, the respect of any respect of one, and just before the respect of one, the insurer had noticed that I said this. Both terms shall be paid in one. The respect of being to be made a party thereto and to defend the action on any of the following grounds daily. These are the grounds of it. That there has been a breach of a specified condition of the policy, one of the following conditions. Daily, the condition excluding use of the vehicle for higher reward where the vehicle is on the date of contract of insurance, a vehicle not covered by a permit to apply for higher reward. Or reward.
No.
Reward means very.
And now you're basing on what you're saying that this can't be on higher or reward.
Well.
One. Yes.
It is used not by the owner for herself for the use of other care. Therefore, it is higher or reward. But it may come within any one of these two. Higher is taking money and then giving the vehicle. Reward is any other form of. But it can be able to basically. How do they say that there is
What do you say on that? On higher and reward?
And the owner purchased the sugarcane from my property and then gave it to the manufacturer for producing packaging. The word purchased is very important. That is an extension of the business agricultural operation of the owner.
No. According to the deposition, he has purchased sugarcane from your.
From payment of the homeowner, that is the father of the deceased.
from your fields and they're carrying it to the some mill.
Some milk for production of agriculture.
Uh,
Now, this purchase, your market may kindly refer to the date higher. Higher means that the tractor was hired for some purpose. That is not the case. I have purchased the owner has purchased the sugar cane from my land. Second one is reward. Reward means any gift or remuneration from any kind. Purchase may kindly say there is no remuneration. Yes, purchase. Yep.
And he's transporting, according to you, is he transporting the goods that are
For
purchased by
example, even when your options an example, that I purchase seeds from a vendor. From a vendor, that would be an agricultural operation. I get the seeds from the vendor and get it to my property. That would be an agricultural operation. Even now I'm trying to expand, the owner is trying to expand his agricultural operation, right? Purchasing the sugar cane. And that is why reward doesn't come into picture. Secondly, with respect to the public places, but illustration, any multiplex or any theaters or any parking lot is involved. If dancing takes place in the parking lot, do I have the right to access? I don't have a right to access Minas. That is not considered as a public place. It is a private property. I don't have a right of access, but I do access with the permission of the marketplace. If the accident takes place, the lawsuit takes this contention into consideration, then it will open up a Pandora's box for that.
Yes,
Even premises of the High Court, I don't have a right to access, but I am entering. I have an access.
anything in reply, Mr. Swan?
What the earliest point of time clearly indicate the nature of the group.
Please come. Yes, please. Agree whether award passing. Seven, dated 21st February 2012. The appellant insurance company is before default. The claim petition was filed under section 10 of the Employees Compensation Act, seeking compensation of an amount of rupees 8 lakhs for the death of the workman who was employed as loader and unloader in a tractor belonging to the first respondent in the accident that occurred on 30/6/2003. The circular, considering the evidence on record, had granted a compensation of an amount of 3,20,355. It's a case of the claimant that the deceased was working in the capacity of a loader and unloader under the first respondent, the tractor trailer, on 30/6/2003. As per the instruction of the first respondent is the first respondent. The deceased workman loaded the sugar cane belonging to Origida, that is, which respondent is he?
Applicant number 2.
That is the father of the deceased. Father of the deceased. Yeah. Taking the jaggery, the by returning the driver of the tractor, instead of driving the tractor in the road right, still on the bunch of sugar, bunch of the sugarcane seed in a rash and negligent manner. Due to this, the loader sitting on the tractor fell down and the tractor wheel ran over him. As a result of this, the worker sustained grievous injuries and died at the spot. The land counsel appearing for the insurance company submits that the accident had taken in a private place, but not in a public place. In such event, the insurance company is not liable to pay the compensation. The others, it is also submitted that it is the policy is issued for the purpose of using the vehicle for agriculture purpose by the owner of the vehicle. Whereas in this case, the sugarcane which belongs to the respondent number, applicant number, the claimant number 2 was taken to the Jaggery unit. No, as per your own case, and he submits that as it is used for hire and reward, which is not which is contrary to the terms and conditions of the policy. Even on that count also, the insurance company is not liable to pay the compensation. He had invited the attention of the court to section 140 147 and submits that relying on 147 1 B2 1 and 2 submits that the insurance company is only liable to pay the compensation if the accident caused by or arising out of the use of the vehicle in a public place. It is submitted that as the accident had taken place not on a public place but in a private place, insurance company is not liable. He submits that even the proviso 2 also says that against the death or bodily injury to any passenger of a public service vehicle caused by or using out of the use of the vehicle in a public place. Then he has drawn the attention of the court to section 149 and submits that if the vehicle is used for hire or reward, where the vehicle on the date of the contract of insurance not covered by a permit to fly for hire or reward, even in that case also, insurance company is not liable to pay the compensation. Then drawing the attention of the court to section 165, and counsel submits that when it comes to section 165, where it mentions about the bodily injury to persons arising out of the use of motorcycle vehicle or damages to any property of a third party. So arising or both, there the public place is conspicuously not present, as it was the intention of the legislature that the claims tribunal has got the authority, got the jurisdiction to decide the same and grant compensation against the owner. But as far as insurance liability is concerned, that is dealt with in the only provision the deals with the same is section 149. One 147 and 149, where the public place is categorically mentioned. Relying on these provisions, then council submits that the insurance company is not liable to pay the compensation. Land council appearing for the respondent claimant submits that in the evidence, it is categorically mentioned that the owner of the vehicle had purchased the sugarcane from the father of the deceased. That is the second applicant, and from those fields, they are taking the jaggery to the mill, the sugarcane to the mill. And in that case, there is no question of using it for hide or reward, as the same is used for the purpose of for the purpose of for the said vehicle is used for the benefit of the owner or for the requirement of the owner. It is submitted that even the accident that had taken place cannot be termed as a public place, as cannot be said that it is a private place. He submits that as the accident had happened in a while they are returning from the fields. And
Returning from the mill, back to the field.
returning from the mill to the back to the fields, where the said place has access to all the public. And once it is a place where all the public have an access, it falls within the definition of a public place as per section 234 of the Act. And it is submitted that the court below had rightly held that the insurance company is liable to pay the compensation. Having heard the land councils on either side, there is the entire material on record. The submission of the land counsel for the insurance company is twofold. One is that as the accident had taken place in a public place, the insurance company in a private place, the insurance company is not liable to pay the compensation. Secondly, the vehicle is used for a high purpose and contrary to the terms and conditions of the policy, as such, the insurance company is not liable to pay the compensation. To appreciate the contention of land counsel for the insurance company, it is appropriate to look at section 146, extract section 146 from the whole law. 147 and section 149 in the law, section 146, 146 only this part you expect from 46 till here. Then when it comes to 147, 1 till here. Then 149 till here. From here to and 165 volt. From here to here. Well, mark.
Station, we can do one or two.
That's what is 147, Roman 1 and 2.
Explanation level. Explanation levels. For clearance of doubts, removal of doubts.
Yes. Okay. The section 234 of the Act deals with, it defines what is a public place. 234, here it is. Let's back to the definition. Defines 234. The definition of public place clearly as it defines that a public place means a road, street, way, or other place, whether a thoroughfare or not, to which the public have a right of access, and includes any place or stand at which passengers are picked up or set down by a stage carriage. In this case, it is the case of the claimant that the driver, instead of driving the tractor in the road, drives the vehicle on the bunch of sugarcane field in a rash and negligent manner. Due to this, the loader sitting on the tractor fell down and the tractor ran over him. By this, the learned counsel for the insurance company tries to submit that it is not a public place, but it is a private place. The said submission has no legs to stand. The reason, admittedly, those are the agriculture fields and all the public and the farmers have access to the bunds to reach their respective lands. As the public have a right to access, the definition, it would very much fall within the definition of public place. Then coming to the use of vehicle as defined, use of vehicle in a public place as in section 147, it says 147 1A 1B Roman 2. Roman 1 says that against any liability which may be incurred by him in respect of the death or death of or bodily or damage to any property of a third party caused by or arising out of the use of the vehicle in a public place. In this case, the vehicle, there is a use of vehicle in a public place, and because of the negligence on the part of the driver of the vehicle, the accident had taken place. Hence, the court below had rightly held that the insurance company is liable to pay the compensation as the requirements of section 166 of the Act are proved by the claimants by using it's an essential workman compensation. They have proved that during the course of employment he has sustained the injuries. Then the other contention of the learned counsel for the insurance company that it is used for hire or reward, and as such, as it is only supposed to be used for an agriculture purpose, but not on hire and reward, as such they are not liable to pay the compensation, also has no legs to stand for the reason the evidence of the father of the deceased, that is applicant number 2, has categorically stated in his evidence that that the vehicle is used for the purpose of carrying the sugarcane, which is purchased by the owner of the vehicle to the mill for the purpose of the jaggery. In the light of the said admission, said evidence of the applicant, it cannot be said that the vehicle is used for the purpose of, vehicle is used for hire or reward. Under these circumstances, this court is of the considered opinion that the tribunal has rightly granted the compensation. In this, before this conclusion, the Honorable Apex Court, in case of Khalil Khan and others versus Timidabi and others, reported in 2018 7 SCC 687. A three-judge bench of the Apex Court has held that whether the accident in question arose out of the use of motor vehicle, a fundamental requirement in a claim under the 1988 Act, use of motor vehicle itself is sufficient. However, there should be a relationship exist between the violation and the accident caused, where the Apex Court in the said case, where in the said case, in the said case where when the motor vehicle owner used battery of the insured tractor to trigger a blast, and when a stone came flying and hit the deceased standing 300 feet away near the shop, causing a fatal accident, held that the insurance company is liable to pay the compensation as there is a use of motor vehicle. Accordingly, the appeal of the insurance company is dismissed. 6%. No, why you have not prepared any appeal?
Even they are not being a cross appeal, the lordships have the power to enhance.
In this case, so there is no appeal filed by the claimant, but the order does not contain the rate of interest. Hence, he is entitled for, the claimants are entitled for interest of 6%. Yes, next. With this fact. Yes. Call the.
Asha Devi, serial number 3.
Damage to the vehicle. How much was claimed by them? How much is awarded?
The only reason critical is that they have not examined the author of the document in the case people will work.
Let us see that finding.
The petitioner in his evidence has stated that the incident accident is part of the statement is for Bangalore to repair and they have difference. One.
So when the accident had taken place,
2010.
and this person purchased the car when? It says the person is a present RC owner. No. It says exhibit P9 issued by the National Insurance Company Limited, with whom the said vehicle sold. The owner of the vehicle has not lodged the motor damage claim till date.
It is not the actual name of the company.
Claimant.
Period from 2010 to 2011. That was the data packet. P9 is the letter issued by the National Insurance Company. This is confirmed that the product and vehicle number. No water body claim has been made with it. There is no body claim made against National Insurance Company. According to exhibit P9. The insurance company which the vehicle is insured stated that the owner of the vehicle has not been lodged the motor claim, water damage free detail. In the case of the petitioner that will be set accident in the vehicle damage, the estimation of the damage cost of the vehicle. We have also produced the estimate. If it is more than
So even the court also, how can without any discussion, court says it has come to the conclusion that it would be 75,000. No, even that guesswork also, these are the damages, like it would be the estimate cost of it, something should have been done. That's not examined anymore.
Documents are not.
He has only placed the estimate.
And the prevention of the ruling of the one of the judgment was 2009, 2009. In the above decision, the High Court has said that where the reliance placed on the record became the it are required to be removed and any other claim. In such circumstances, we are derived from the document is no delay. In the case on hand, the author of the document estimates that the individual is not examined and more of this not being retired. In the
Is an appeal filed by the claimant. Agreed by the Lord passed in MAC number 7983 of 2010, dated 16th August 2011. The claim petition was filed seeking damages to the vehicle. Claimed an amount of rupees 3 lakhs, and the court below had granted an amount of rupees 75,000 as compensation. This matter came up before this court on 14/9/2023, as there is no representation. The matter was posted for discussion today. Today also there is no representation on behalf of the appellant. As this is an appeal of 2012, I learned counsel for the respondent present. As this is an appeal of 2012, this court is inclined to proceed with the matter on the verdict of the case. In the grounds of appeal, it is stated that when they claim the compensation of 3 lakhs, the tribunal erroneously, without application of mind, awarded compensation of 75,000. The photos clearly reveals that the vehicle is totally damaged, and it cost as good as buying a new vehicle. The court below had not considered the documentary and oral evidence in support of the claim. Then counsel appearing for the respondent insurance company submits that the claimant has filed before the court exhibit P10, the estimated bill, P11 invoice bill, P12 34 photographs and negatives, and P13 is a tax invoice. It is submitted that admittedly no survey was conducted, no surveyor was appointed. That's what the court says. That he has not surveyed the damage caused to the vehicle to the concerned surveyor. And even the vehicle was not repaired till today. The person who has given the estimate, he was not examined except marking the estimate report, estimated bill, exhibit P10. He submits that there is no evidence. Court below had rightly granted. He submits that even the amount that is granted is on the higher side. And the tribunal, without any basis, has granted an amount of ₹75,000. This court has perused, having heard the legal counsel for the respondent, has perused the entire material on record, as rightly pointed out by the legal counsel, and as observed by the court below, except filing the estimated bill, the claimant had not taken any steps to examine the concern in support of his case, and he has not even appointed a survey. He has not even surveyed the damages caused to the vehicle through the concerned surveyor. These facts, the court below was has rightly granted the compensation 75,000, and this court finds no reason paper. Yes, make accordingly appeal is dismissed. Yes. You ready? Yes. That's it. Yes.
On 14/8/2006,
Please come to the para, we'll read.
that the provision had reached the time.
No, it will save the time if the court reads, then you can submit your submission. Which para?
Then on the facts, it's a page 3.
Yes, please read.
The petition came by him in the accident down that he 3:45 p.m. He was proceeding near Peanut House at Varikopar Road, this sunset. And at that time, the auto rickshaw bearing number A17 940, driving by respondent number 2, came from opposite direction. The respondent number 2 was driving the auto rickshaw back in a negligent manner. And as a result, auto rickshaw dashed to the right side of it. As such, the petitioner sustained serious injury in the accident and has taken treatment by spending more than ₹75,000. He was aged about 45 years and having knowledge business, thereby earning ₹8,000. Because of the injury sustained in the accident, he lost the learning capacity against him. On the other hand, Manoj, respond paragraph 4, page 8.
I see that your content.
The tribunal has rightly held Manoj on 14/8/2006.
Let's come to issue number 183 and issue number 1.
Respect to that, here record, very widely The accident has taken place on 14th. 15th, and the injury suffered by him is with respect to his leg, that is right knee. On 15th, Manoj, he himself gives the complaint.
On 15.
Gives a complaint wherein he specifically mentions that the auto rickshaw bearing KA 285242 was the auto rickshaw that has caused the accident. Further, based on that statement, the FIR has been registered. Because the tribunal has rightly held, right, during the course of evidence, the counsel for the respondent, the insurance company, has cross-examined with respect to this aspect. Wherein he admits that whatever the statement that is given or the complaint that is given, he was aware of it and he acknowledges the content of that complaint and even the FIR. The tribunal has rightly held that here.
We have to make the mark for her to get taken that. We have marked that. Yes.
Aware of the vehicle number, it is impossible for them to fix another vehicle. Furthermore,
Let us see the list of submitting that if the court needs it easily.
one last confusion is.
No, I'm saying you can make all those submissions after reading this.
The recording number 1 to 3, alternative 3, have admitted that the petitioner has sustained injury in the motor vehicle accident that took place on 14/8/2006 at about 8:45 p.m. The Srihari house at Marikopa Road at Pune. Respondent number 3 denying the involvement of the vehicle. Respondent number 1 with a plea that the vehicle carrying the registered number 4. During the course of evidence, the respondents have admitted the accident in the injury sustained by the petitioner in the accident. To prove the accident, petitioner has produced FIR, complaint, sheet, additional statement, statements of witnesses, Panchanama, food certificate, notice issued by the investigating officer to the petitioner, and the discharge card. Exhibit P1 to P12. These documents also indicate that the petitioner sustained injuries in motor vehicle accidents and not from any other cause. The PW 1 and 2 have also spoken about the injuries sustained by the petitioner in the motor vehicle accident. The treatment of such injuries. So these materials on record are sufficient to hold that the petitioner sustained injuries in the motor vehicle accident that took place on 14 at about 8:45 p.m. in Maricopa Road. It is a specific plea of the petitioner that auto rickshaw bearing number A70A940 driven by the respondent dash to his license. This fact has been denied by the respondent. The respondent number 1 and 2 have contended that because of evasion of petitioner, there was collision between the right side of petitioner and auto rickshaw bearing registration number A70A940. So the respondent number 1 and 2 are not denying the involvement of the vehicle in the accident. Whereas the respondent number 3 is categorically denying the involvement of the respondent number 1 in the accident. In order to substantiate the contention, respondent number 3 relied upon the contents of exhibit P1, 2, 10, and 15. Admission given by PW1, RW1, and 2, and the evidence of RW3. The exhibit P2, which is first information given by petitioner to the police on 15/8/2006. He has specifically stated that auto rickshaw bearing register number KA285242 dash to this effect. On basis of such statement, Pune police has registered the FIR at exhibit P1, showing the same vehicle number.
No, there are two vehicles. One is 52421 First vehicle, when he gave the complaint, he said that K285242 was a vehicle which is the tricycle. Then after that, he gives another number, 17A940. Now, which insurer or the owner of the vehicle is now before the court?
Sure, it is preferred by the payment.
No, that's what I'm saying. No, not before the court means not before the court. Before the tribunal, which vehicle is which vehicle's owner is shown as owner and insurer are parties. So this vehicle, the second vehicle. So exhibit P1 initially gave the complaint that KA 28 5242 is the vehicle involved. Later by some additional statement, he says that it is not that vehicle, it is this vehicle. Somebody, whoever was there on the at the spot, for the public informed him.
So on that basis, Manoj, the tribunal has said that, and further, Manoj, even exhibit P50, which is the IMV report of the vehicle bearing K17A940. There, Manoj, even the vehicle inspection, there is no damage to this particular, the second author.
Right.
On these grounds, Manoj, the tribunal has said that there is a wrong fixation of the weight.
When was the MB report?
The IMV report, Manoj,
2/9/2006. That is after 15 days. They don't even say that who was driving the vehicle at that relevant point of time. The owner of the vehicle. R1 and R2, driver of the auto rickshaw. Both of them say that they came to know about the accident after 2 days.
the driver came to know about the accident 3 days later. The owner came to know about the accident 50 days.
No, they do admit the accident.
They do admit, Manoj, but sure, our contention is, Manoj, even while admitting, they also give out the details of the first auto accident. Where the owner of the auto, he also gives out the information saying that the auto bearing the first auto on the day of accident was present in that particular spot, in the particular village. And he also gives out the details of the owner of that one. It's highly unlikely, Manoj, during his accident, he give out the details of the owner.
This is an appeal filed by the payment. Agreed to the law passed on December 28 of 2007, dated 19 January 2012. The claim petition is filed, so she agreed with the dismissal of the claim petition. Present appeal is filed. matter came up when this matter came up before on coming up to final hearing, is an appeal of 2012. There is no representation on behalf of the appellant claimant. Then counsel with the respondent insurance company is present. As is an appeal of 2012, this court is not inclined to adjourn the matter and proceed with the same based on the material on record. According to the claimant has filed the petition seeking compensation of an amount of rupees. How much was claimed? Claiming compensation on an amount of rupees 10 lakh. In this case, it is the case of the claimant that on 14/8/2006 at about 8:45 p.m. he was proceeding near Sri Hari House at Maricopa Road on his bicycle, and at that time the auto rickshaw bearing registration number K17/A-940 driven by the respondent number 2 came from opposite direction in a rash and negligent manner and hit the tricycle. He sustained grievous injuries. Spending an amount of rupees 75,000. On the date of accident, he was aged 45 years and having a laundry business and earning 8,000 per month. It's the case of the insurance company that is the respondent number 3, that the accident, the vehicle is not involved in the accident, and for the purpose of claiming compensation, they've implicated the vehicle. The driver of the vehicle as well as the owner of the vehicle were examined as RW1 and RW2. According to them, the accident had happened. The owner came to know about the accident after how many days? 15 days. And the driver came to know about the accident after 2 days. 2 days. The court below had, while discussing the claim petition, observed that the accident, there was an accident and the claimant had sustained injuries. There is no dispute about the fact. When the accident had taken place on 14/8/2006, on 15/8/2006, he has given a complaint to the police. In that, vehicle auto rickshaw bearing number K285242 as was involved in the accident and hit his tricycle. Later, he gave a statement before the police. That is exhibit P2, stating that.
Exhibit P2 is the complaint. Exhibit P1 is the FIR. Exhibit P4 to P6.
P4?
P4 to P.
Or
That
he has given an additional statement before the police stating that as on the date of the accident, as it was a night time, it was dark, he was not in a position, he couldn't see the vehicle, and basing on the information, he gave the number as KA285242. Later he came to know that vehicle number KA17/940 hit his tricycle. Court. And basing on that, the police have conducted the investigation, filed the charge sheet, and even the driver of the auto rickshaw has accepted the guilt. The court below, relying on the judgments of this court, has observed that mere filing of a charge sheet and admitting the guilt by the accused itself cannot be a ground to come to the conclusion that the vehicle is involved in the accident. In this case, there is no eyewitness to the, no, anybody examine? There is no eyewitness to the incident. The evidence of the owner and the driver also do not inspire confidence in the mind of the court about the accident, as they say that they came to know about the accident about the driver after 2 days, the owner after 15 days of the accident. Basing on these evidence, court had come to the conclusion that the involvement of the vehicle is doubtful, and accordingly dismiss the claim petition. Learned counsel appearing for the expirer. Insurance company submits that so for court below, considering the very admission of the claimant, wherein he had given two numbers, both the numbers he had not seen, but he was informed by the public who gathered there, coupled with the evidence of RW1 and RW2, court had dismissed the claim. He submits that the evidence on record clearly shows that the said vehicle is implicated in the case for the purpose of claiming compensation. Next part. Having heard the learned counsel of the respondent, this court had perused the entire material on record. The court below gave a categorical finding about the non-involvement of the vehicle in the light of the evidence of the claimant himself and the evidence of RW1 and RW2. Court below was right in holding that mere acceptance of guilt by the owner, by the driver of the vehicle itself cannot be a reason to believe the evidence of the claimant with regard to the involvement of the vehicle. Considering the evidence of the claimant himself and RW1 and 2, this court is also considered opinion that the court below has rightly dismissed the claim petition. Finds no reasons to interfere. Accordingly, appeal is dismissed. Yes, next. Yes.
I am for the respondent claimant, my lord. I have filed appeal also. I am ready for arguments, my lord.
Sir, on your own liability or on front? How much was the claim? How much? How much was awarded? 2,36,800. Case of injury. Any disability? Yes, Mr. Latur, any disability?
Yes, my lord. Here is a case of head injury, my lord. Head injury, and he was
As per
unable
the doctor,
to
how much is the disability?
decide. 29.5% has been given by the neurosurgeon.
29.9. How much the court has taken?
Court has taken 10%, my lord. 29.55. I am sorry. 29.55
What was
is
the
the whole
occupation?
body disability taken by the given by the doctor, my lord.
What was
And
the
my lord,
occupation of the claimant?
is a tailor, my lord. Is a tailor.
Earning how much?
He was earning rupees 6,004 per month, but tribunal has
6,400.
taken 4,000 has taken, my lord.
6,000 is earning.
He
4,000
was
is
earning. Taken 4,000.
First we'll hear him on liability. Yes.
Yes, ma'am.
When was the accident?
2009.
8/1.
2009.
When was the complaint given?
Complaint was given on the next day.
By whom?
The right of the. Who is the PW, right?
What did he say? What was the reason of the accident?
Yes.
Oh, presence of alcohol is also mentioned.
And there also,
What was the explanation of the payment of that?
and there is another item, which is he is sitting behind, and due to his negligence, he fell from the motorcycle.
It's a triple riding according to.
So,
So you say by behind him somebody else was sitting.
no, this Mr. Muslim was on there is trained that it will be by access. He's on a well, but he's
So now the claimant is a pillion rider.
access was on another motorcycle. His statement is that it was access, it was the limit was running. The medical report also reflected there was.
According to the claimant, he is not the rider, he is a pillion rider. Who else was examined?
The here was the claimant, despite the doctor giving evidence, that he can proceed with daily activity. So he is not given.
No, we are on the liability, not on the quantum. So on the liability, now where is the evidence of what is the other independent evidence?
He himself has given the reason to be actually. There are others,
PW5 says that it is a self-fall. He is the one who given the complaint. Huh?
He's the one who's.
Before the court, what did he say?
He says that he will.
No, PW5.
The price is that he will be.
The claimant was a pillion rider. In police complaint, he says otherwise. He's a pillion rider. No, what did the claimant say about the entries in the medical record? Why the claimant has not entered into the box?
No difficulties for him to come and tender evidence. Here, they have asked the father to come before the.
So is it the case that he was not in a position to come and depose?
It is their contention, it is their case that he is unable to come, hence the father is. The claimant has a PW5 with the identity.
So if he cannot come, even by way of a commission, he can be examined. Please come to the order. Let's see how the court has given a finding on that. Which para? About the accident. Is this Hussein examined? who is this Asif? Is PW5? Exhibit P11, which is emergency case register, para number 12 of the judgment. No, let's read that also. And what did you elicit in the cross examination from PW5? PW5 is Asif. Is it in Kannada or in English? Right? He was shifted to Nimhans on the same day. Report was given. No, report was given. Police complaint was given on the same day or the next day. So before Nimhans and before the police, their case is one and the same. Only at the immediately after the accident where they have gone, in that MLC, it is mentioned that it is a self-fall. And admittedly, at that point of time, the claimant was unconscious. And no injuries to the rider? Case is not registered against him. Then against whom? Must have been registered.
My lord, he was admitted to the Chikbalapura Government Hospital first time. Thereafter, he came over to the Nimans Hospital.
Why the claimant was not examined?
Claimant, he was unable to give evidence before the court, my lord. It has come in the evidence of doctor also. It has come in the evidence of petitioner PW1, is the father of the petitioner, my lord. He was unable to speak and he was unable to remember anything.
Evidence? With evidence. Evidence of PW fight and the doctor, both people are. I'm looking at the PW fights evidence. No, about Hussain also, there is Zakir Hussain had sustained simple injuries. He was also taken to Chikballapur Government Hospital. Zakir Hussain, who has given all these details to the you have not even one suggestion to him. When you have when you are the one that is PW5 is the one who has admitted the claimant to the hospital. This is what you have stated before the hospital authorities about the cause of accident, and now before the police you have given some other statement. Nothing has been put to him. No cross examination on that aspect. You didn't even no suggestion at all. No, the fact remains he is unconscious. The claimant was unconscious. How can it be a self-fall? No, at least you have to establish that at that time he was only riding the vehicle. Police records must be in favor of the claimant. Let us now read the doctor's evidence.
Lord, the accident has been registered within 1.5 hours after the accident. Within 1.5 hours. Wherein it has been mentioned that he is a pillion rider. He is a pillion
1.5 day or 1.5 hour?
1.5 hour. 1.5 hour. Complaint was registered within 1.5 hour from the time of accident.
Let's see the doctor's evidence.
Yes.
What did you elicit? Nothing. You have not even one question in the cross-examination. Look at your cross-examination.
Even in objections also,
No
they are
efforts were made by you to elicit anything from them. Then let's see, please come to the doctor's evidence. No, he is not the treated doctor.
yes, my lord, I agree. He is not a treated doctor because he is a neurosurgeon. Therefore, I examined him, and I have examined from the Nimans Hospital. who brought-
No, this doctor, what did he say about
Yes.
the disability on basing on what he's saying that the disability so and so. Let's see that. Very badly, cross-examination of the doctor is also like that. So let's see from para 1. He says he was immediately taken to Limhans Hospital with a coma score of 7/15. So we'll understand what is this, the health condition. A CT scan was done. There had revealed a right parietal acute blood clot outside the brain, but inside the skull. Hmm. Where do you get that? Para 2 of the doctor's evidence. Just now I read. He came to his wife. He came to me with his wife Read from there.
For the first time, for 3 months after the road accident, 80% of the for the road not be able to dispatch the work. Further, there have been some behavior which is after the road accident. And further, apparently, other habits in most of the activities.
No, he has been physically challenged in both fields. Physically challenged. You know, we are on his mental status now for the injury. So it will not have any impact on the. The doctor's evidence is also about his mental disability, not the physical disability. Let's read. The patient, he has been physically challenged in both fields since childhood. Then how can he drive the vehicle? So we have to believe the evidence that he is a pillion rider.
My lord, with the similar facts of the case, our own High Court has awarded the compensation. I have produced the decision also, that is in 2016 AAC 2344. 2016 AAC 2344. Wherein
You have put some judgment 2018, 1 KCCR 351.
2018 KCCR 351 is for the proof of medical entry, my lord, records entry. That has to be proved by the respondents. And this is all second one also.
The judgment which is available here. There is any other judgment? What is that judgment?
That in 2018 KCCR 351 is Yellappa Sivappa Sajali, my lord. In this case, if the medical entry, that is the hospital entry, without proof cannot be considered, my lord. That is the only the person who has given the history to the doctor and the person who has written the history of the doctor has to be examined before the court, my lord, to believe that sentence. Here, they have not examined any persons to prove that.
Document.
The same, both the decisions says same, this one, my lord. Principle.
Please come to the compensation that was awarded.
For the compensation has been awarded by the tribunal is meager compensation.
Let's see.
Only it is a case of 100% loss of earning capacity, my lord. Now even he cannot do any work, my lord. It is a whole body disability. stated by the doctor, my lord. 29.
What was his earning?
He was earning 6,000 rupees, but as per the chart, it has to be taken 5,000. As per the legal chart, it has to be taken 5,000. Income. And no, my lord, the pain and suffering, our own High Court has awarded, my lord. 1,50,000 rupees is the same type of case, my lord. May I read the decision, my lord? A division bench decision of this honorable court.
You are not disputing the medical expenses.
No, my lord. I am not disputing the medical expenditure.
Court has not considered it.
Medical
And
expenditure.
85,000 you are not disputing.
Yes, my lord. Yes, my lord. And with regard to the laid up period, loss of earning with regard to the laid up period has to be taken
85,000.
some more months, my lord.
Then loss of, please wait for a minute, towards loss of income during treatment period. No. He had taken treatment for how long?
Up to the date of trial, my lord. Even
Then
he was in such a
this loss
condition.
of income during treatment period, if you are not able to work forever, then under the disability category it will come.
No, up to the date of trial, it has to be taken, my lord, because as per the R.D. Attangadi case, 1995 HJ 366, my lord, wherein in such a type of cases, the Honorable Supreme Court held that up to the date of trial, the compensation has to be awarded for the loss of specific
on
earning.
that.
Loss of specific earning.
You say on that, what he says is, now because even till the date of trial, he couldn't work. So from the date of the treatment or his entry to the hospital till the date of trial, as per the Supreme Court judgment, it has to be considered for this loss of income during the treatment period. Doctor says that according to them, he is not able to do all his personal work and all. The doctor said that as per his clinical examination, he is able to do all his daily activity. But as far as now, with all the disability he has mentioned, unlikely that he can continue his tailoring work. According to their evidence, he is not working. No, waiting to deny his application. You have not denied that.
However, it is the they have to also be part of the curriculum that is.
He is a tailor, according to them. Let's read that, where the tribunal gave a finding. It's a C, internal page 14.
Yes.
PW5, who is an eyewitness to the accident, has also deposed during the course of his cross-examination that the petition is a tailor by profession. So loss of income during the treatment period, this will take 5,000 as the income because he's a tailor, skill job. So 5,000 into how many months? Yes, Mr.
Up
Lathur.
to the date of evidence, my lord.
Who will
Because
tell that up to the date? That date I'm asking.
yes, my lord. I'm giving that.
When was the accident?
Accident
Accident is
is
on
on.
8/1/2009.
Yes, my lord. 8/1/2009. Evidence was given on 15/8/2010, my lord.
So how many months? 1.5 years.
8 months at least. The evidence of the petitioner, my lord.
You said what was the date?
Date on
8/1/2009 is the accident. When
yes,
was you giving the evidence? When did you give the evidence?
the evidence of a petitioner PW1 has given the evidence on 15/8/2010.
So it is 12 plus 8, 16 months. That you should have insisted for. That you should have insisted for at that time. That without there should be some commission, something you want to cross-examine him, or you want to examine him. You should be examined. Some effort should have been made by you. So this 5,000 into will take 12, 60,000. Which is a judgment in this regard?
RD Hattangadi 1995 ACJ. RD Hattangadi case, my lord.
Attangari.
RD Hattangadi.
Reported in?
1995 ACJ 366.
1995. Huh? Oh, after hearing for such a long time, now the court will not even remember the facts. Do some exercise, will pass over. Look at that. Pass over. Next. Serial number 7. Harish, please. It's an insurance company appeal. Oh. Was it heard by this court earlier? Oh. Oh. Yes. When do you want?
Last time I had found that we were in the hospital.
Then counsel for the respondent submits that then counsel representing counsel for the respondent submits that he suffered a heart attack. Post this matter after 4 weeks. Yes, next. Stroke. Paralytic stroke. Who appears to the respondent? Mr. Shivalingaya. Mr. Mahesh. Mr. Mahesh. He's not there. He'll pass over. Please pass over. Take up after lunch. No one is there.
My lord, this matter, my lord, serial number 9.
Yes.
My lord,
I pray for a Milad. It may kindly be called on Tuesday, Milad. This is second round litigation. I will have to get previous Milad papers. Milad may kindly call it on Tuesday, Milad. I'll get the papers and appear.
The request of Learned Counsel for the respondent finally post on Tuesday, item 9,
Please, Milad. Oblige.
signature.
ఇప్పుడు చెప్పండి ఆర్టీ బుక్స్ మంది చంద్రబాబు భద్రత ఇబ్బంది దోమలు కొడుతున్నాయి సాఫ్ట్వేర్ అప్లై ఆ పిటిషన్ లో చాలా స్పష్టంగా హౌస్ అరెస్ట్ ఇవ్వాలి చంద్రబాబు కారణం ఏంటంటే మాజీ నక్సలైట్స్ గంజాయి స్మగ్లర్ ఎర్ర చందనం స్మగ్లర్ ఫ్యాక్షనిస్ట్ అంటే ఎవరిపైన అయితే చంద్రబాబు నాయుడు గారు గత 40 సంవత్సరాలుగా రాష్ట్రం కోసం వాళ్ళపైన దాడి చేశారో వాళ్ళు నియంత్రణ చేశారో వాళ్ళందరూ ఈ రోజు జైల్లో ఉన్నారు. దానివల్ల చంద్రబాబు నాయుడు గారు ప్రాణానికి హాని ఉంది. ఈ హౌస్ అరెస్ట్ ఇవ్వాలనేది దానిపైన ఈ వాదన జరుగుతుంది, తీర్పు రావాలి ప్రభుత్వం. అది వచ్చిన తర్వాత భవిష్యత్ కార్యక్రమం మిల్క్ అనేది అందుకే మిల్క్ మేము పాలు సప్లై రేపు తెలుగుదేశం పార్టీ పార్లమెంట్ స్థాయిలో సమావేశాలు ఏర్పాటు చేస్తుంది. అక్కడ ఎల్లుండి నుంచి అన్ని నియోజకవర్గాల్లో భవిష్యత్ కార్యాచరణ ప్రకటించుకుంటున్నాం. ప్రజల లెక్క చైతన్యం తీసుకురావాలి. అదేవిధంగా మన నాయకుడి పైన జరుగుతున్న దాడి, పెట్టిన దొంగ కేసులు ప్రజల్లోకి ఎక్కడ తీసుకెళ్ళిన దానిపైన రేపు అన్ని పార్లమెంట్ ఎల్లుండి నుంచి ఆ కార్యక్రమం Port officer? Port officer? Hello. Hello.
Yes, sir.
Hello.
ಹೇಳಿ ಸರ್.
ಮಧ್ಯಾಹ್ನ ಸಿಟ್ಟಿಂಗ್ ಇದೆಯಾ ಮೇಡಮ್?
ಇದೆ ಸರ್, ಇದೆ.
ಅದು ಸೀರಿಯಲ್ ನಂಬರ್ 18
ಸರ್ ಸೀರಿಯಲ್ ನಂಬರ್ 8 ಪಾಸ್ ಓವರ್ ಆಗಿದೆ ಸರ್, ಇದೆ.
ಓಕೆ, ಥ್ಯಾಂಕ್ ಯು.
Yes. What do you say on that? We are at loss of money. Huh. Hmm. Yes. He says that it's a case of paraplegia and the facts will not apply to this case.
The same, my lord, because here also he cannot do any work, and here the evidence of the doctor is also same. Under that circumstance, the Honorable Supreme Court, it
No,
is
where
not.
did the doctor say that he cannot
No,
work?
no. No, my lord, I
Yes,
will
so-
read the evidence. Yes, there is an evidence of doctor also.
That I have seen, that relevant portion you please read, that he cannot work.
Yes, my lord, it is not, it is there in the evidence of a doctor. I
That
will read.
relevant portion of it.
Yes, my lord, I will read it. Page number 3, my lord, page number 3.
Sheet.
Page number 3. Here, the final whole body disability due to the permanent physical impairment in neurological conditions, 29.55 has been stated by the doctor, my lord. The evidence of doctor, PW4. The above disabilities, especially the impaired working memory, visual spatial working memory, set shifting, and concept formation, and perversion and visual spatial orientation will definitely come in the way of his effective functioning as a ladies tailor or some other similar activity. In view of these disabilities, the petitioner cannot work as a tailor and cannot do any other manual work also. This is an evidence of a doctor, PW4, my lord. So, my lord, when he was even at the time of evidence also, he was dependent upon some other persons. It has come in the evidence also. He has given the evidence through some other person. When he is so much unable, why he is not entitled to claim the compensation up to the date of trial as per it is a law laid down by the Honorable Supreme Court in this 1995 ACJ 366. Though the injuries are different, my lord, but the law has been laid down.
For the loss of for the future earning, disability, how much is considered? 10%. Yes. No, all these injuries, when he's a pillion rider, towards loss of future earnings, this doctor has said 20.
9.55 is a whole body disability, my lord, not a particular limb.
You take 15%. 5,000 into 12. What is the multiplier? 16.
No, my lord, my submission may kindly be noted. Here there is a decision of another Supreme Court decision wherein Honorable Supreme Court held that if you want to disbelieve the evidence of a doctor, there must be some rebuttal evidence. It is a decision to 2012 ACJ 1459. The Manoj Rathore versus Anil Raheja and others. Here in this case, the Honorable Supreme Court held that if you want to disbelieve the evidence of a doctor, then there must be some rebuttal evidence from the respondents to show that there is that the evidence of the doctor is wrong, my lord. So here, may I read that relevant para of the judgment of the Supreme Court? Yes, ma'am. Para 10 of the decision, my lord, here in this case, respondent number 3 did not adduce any evidence to establish its plea that the disability certificate was fake or that the assessment made by AW2 was not correct and the appellant could continue to do the work with the same degree of efficiency as he was doing prior to the accident. Therefore, it is not possible to approve the view taken by the tribunal and the High Court that the appellant had not suffered permanent disability due to the fracture on his right thigh and that his working capacity did not get impaired as a result of injury caused in accident. In view of the above conclusion, we may have set aside the impugned judgment and remitted the matter to the High Court for fresh disposal of the appeal, but keeping in view the fact that the period of more than 4 years has elapsed from the date of accident and the appellant has already suffered a loss of income, we do not consider it proper to adopt that course and are convinced that ends of justice will deserve to be by directing the respondent number 3 to pay a lump sum amount of rupees 3 lakh to the appellant manner. Here, the Honorable Supreme Court directly held, even in on our own High Court, the full bench decision, Sivalinga Gowda case, my lord, because the disability has been defined under the Workman Compensation Act, not under the Motor Vehicles Act. So, under the Workman Compensation Act, full bench decision of our own High Court held that if you want to disbelieve the evidence of a doctor, then you have to get it examined by some other doctor also. The minimum, at least to the decision of our own High Court that I have produced before this Honorable Court, wherein 32% disability of the whole body.
To 4,60,000.
My lord,
Pain and suffering 1 lakh. Towards medical expenses 25,000. Loss of income during the later period. Then that we will see. Loss of income during the treatment period. If 5,000 it is 50,000. No, what will you say? We'll say that during the later period, if you're considering the this loss of earning, admittedly, as on that day also, he is not in a position to work. Why not that will apply? Just because the same disease need not be there. That is, that component is allotted, is awarded, amount is awarded for the loss of earning. Now, as on that day, he is not all right. He was not earning. Daily activities, no, daily activity is one thing, and doing his job is different thing. What are the efforts from you? What are at least your, by way of your argument? You have not addressed any argument, any of your submissions on that.
Even the doctors is a record. He said that he can take care of. He's able to
Do the daily activity. He's able to sit, he's able to stand. That's what he's free to. When they said that, for all those activities, he requires somebody's help. Or that the doctor said. That was the suggestion given to him. There is nothing from your side. You don't have to do anything. When there is a convincer, when he is not in a position to come and depose, you should have taken that when he is the claimant, when he has not entered into the witness box, you should have raised that objection. And so that then adverse inference has to be drawn. You have not contended. You have accepted that you also no objection. That's why I'm asking. In any of the arguments or anywhere, did you take that stand? No. You have not taken. Then what about the medical bills? You're saying it's double. From where you get that? Then we'll make it 80,000. For 5,000. Who had given 85,000?
May I submit, my lord?
Yes.
In a 2016 AAC 2344 division bench decision of our own High Court. Similar facts of the case, my lord. There only 32% is whole body disability. Here in this case, 29.55% whole body disability. The same case, my lord. The Honorable, our own High Court division bench has awarded the compensation. That may kindly be taken in this case as a guidelines, my lord. Here,
It comes to 4,85,000. We are considering only 30,000 instead of 60,000. Pain and suffering 1 lakh, medical 80,000, loss of income during the treatment period 30,000, towards loss of future earnings 5,000 to 12 into 16 into 25 by 100, loss of amenities and happiness, court has granted 15,000, this court is granting 25,000, legal expenses 10,000, it comes to 4,85,000. Yes, Mr. Lathur, it comes to.
my lord, I am submitting a decision of our own High Court division bench. The same facts involved in this case. 32% is there the disability. In our case, 29%, 55%. The Honorable our own High Court has held that here 1,50,000 injury, pain and suffering has awarded. 1 lakh towards loss of amenities has been awarded, my lord. Towards medical expenditure, 4,74,000, and towards conveyance, nourishment, food and attendance, 50,000, and towards loss
Is awarded. Transportation
of,
and nothing is awarded.
so loss of amenities, my lord. He throughout the life he has to live like this, my lord. Handicapped person.
Huh? What do you say about the loss of amenities? No, considering the disability of 25% and the impact it would have on his life. Considering the disability and the impact it has on his life, what do you say on amenities? Court has granted only 15,000. Court has already enhanced to 25,000. Already granted transport, conveyance and attendant 30,000. 30,000 for his prolonged treatment and the prolonged, it comes to 5,15,000. No, unfortunately, neither the PW4 or the PW5 cross-examination, he has not suggested anything. They have not elicited anything from the doctor to disbelieve his evidence. At least not even a suggestion saying that he has not sustained that much disability. The percentage is excessive. Nothing of the difference. So there should be a reason to disbelieve work. Doctor, court is not the technical person to say that whether it is, and he has given all the reasoning for that as per the so and so guideline, as per Revenue Hands. This is what it is. It amounts to this much. He made a calculation and then arrived at a. That also he has given in the evidence. No. Where is I please read? That's not a day. Give the evidence. Read the doctor's evidence. First, read the chief. Finally, whole body disability is so and so. Beneath that, please read. Yes. Please come. Read brother. Award starts from NBC number 3288 of 2009, dated 19th March 2012. Both the insurance company as well as the claimants are before this court. Insurance company's appeal is numbered as MSA number 9878 of 2012. The claimant's appeal is MFA 7929 of 2012. The claim petition is filed seeking compensation of an amount of rupees 8 lakhs for the injuries and the disabilities sustained by the claimant in the accident. The court below had granted an amount of rupees 2,36,800. The case of the claimant is that on 8/1/2009, the claimant was proceeding on a motorcycle as a pillion rider along with one Mr. Hussain. When they were proceeding near BTS school at about 5 p.m., there was a hump on the road. The rider of motorcycle, without observing the hump, drew the vehicle rashly and caused the accident. Due to the impact, the petitioner, who was the pillion rider, fell down from the motorcycle, sustained grievous injury. The PW5, who was traveling on other bike along with the claimant, had taken him to the hospital. Initially, he was admitted in which hospital?
Government hospital, Chikbalapur.
Government Hospital, Chikbalapur. Thereafter, he was shifted to Nimhans Hospital. As per the doctor, he had sustained 29.95% disability to the whole body. Basing on this, the court below, under the head of pain and suffering, granted an amount of rupees 40,000. Towards medical expenses 85,000. Towards loss of income during the treatment period 20,000. Towards loss of future income 76,800, offsetting the disability at 10%. And towards loss of amenities 15,000. Altogether, an amount of rupees 2,36,800 was granted. Land counsel appearing for the insurance company submits that immediately after the accident, when the claimant was admitted in the government hospital by PW5, in the MLC register of the government hospital, it is mentioned that he has sustained injuries as it's a self fall from a vehicle. It is submitted that thereafter a complaint was due. And he was under the influence of alcohol. Thereafter, he was shifted to Nimhans. And in the medical records of the Nimhans hospital, it is mentioned that he is a pillion rider and he fell from the scooter because of the negligent driving of the rider of the vehicle. He submits that in the complaint also, it is stated that he is a pillion rider. The counsel, basing on this, submits that The manner in which the accident had taken place itself is doubtful, and the medical record of Nimhans and the police record is contrary to the medical record of the government hospital Chikbalapur. Correct? Huh? In the no, Nimhans it is mentioned as I have seen that. Let's see. Nimhans it is not mentioned like that. Where do you get that? From the judgment?
My lord, in the first hospital, government hospital, own certificate has issued exhibit P5, wherein it is mentioned that he was a pillion rider. And there is also a outpatient record also has been produced, wherein also going in the two-wheeler has been mentioned. Subsequently, in the Nimans, subsequent hospital in the Nimans, it has been mentioned as he was a rider. He was riding the vehicle. But that sentence.
Petitioner has also produced a sheet of Nimans as exhibit P11. Hence, by looking into the medical records, it is evident that for the severe head injury, he had been treated as inpatient for a total period of 28 days at 2 different hospitals. It is marked as exhibit. No, it is marked as exhibit P11. Then the further discharge summary says something else. All from two-wheeler. They don't say. Just says fall from a two-wheeler on 8/1/2009 at 5:30 p.m.
Exhibit P5 and P6 mechanically.
Exhibit
P5 and P6. Wound certificate and the outpatient slip.
what I'm looking at.
First time he was
Is there
admitted
in
to
that?
the first time he was admitted to the government hospital, wherein
Exhibit
P5.
P4 motor vehicle accident report and the wound certificate of Karnataka Medical Government Hospital.
Yes, my lord. In that said that he was going on a scooter, man. He was going
Where
on
do
a
you
scooter.
get that? Please read. Where do you
I
get that?
will read, my lord. I will read, my lord. In a wound certificate,
Yes.
here, history of RTA
Yes,
RTA alleged on 8/1/2009 at 5 p.m. while going in two-wheeler K 51 55 21 while going
look
and
at
also
exhibit.
in a next
They
exhibit
don't
P.
fall from the bike.
Yes, my lord. Fall from. Even in the exhibit P6 also, next to page, patient
1 minute, let P5. Nine to 2003. Okay. While going in a two-wheeler.
yes, my lord. After 1.5 hours, the complaint was filed, my lord, after the accident. The time of
Even
complaint.
next page also, while going on a two-wheeler, exhibit P6, a small slip. So you have seen exhibit P7. P7. No, you see P7. P6, not P7. P6. A small slip like this. It is also like how it is on exhibit P4, 5. Now come to P7. This is a discharge summary of NIMHANS. Now, complaint is given, the police complaint within 1.5 hours from the day, from the time of accident. In that it is mentioned as a pillion rider fall from a kind of a meticulous analysis can be done in this. When it comes to Ashwath Hospital, huh? RTA sustained head injury. So even at the earliest point of time, it is fall from a two-wheeler. NIMHANS is the second hospital. What did I say? In NIMHANS medical record, he stated that he is riding the vehicle, whereas in the government hospital, it is that he is traveling on a two-wheeler and a fall from two-wheeler. Two-wheeler. This is the contention of that line. Varna. You are recording the contention of that line. Basing on, he submits that that he was not, the claimant was not examined. The doctor who has given the evidence about the disability is not the teaching doctor. The court below so comes to the conclusion that the medical bills are the court 80,000 but grants an amount of 85,000 towards medical bills. He submits that the court below has granted held the insurance company liable when there are so many contradictions in the evidence, and the amount that was granted by the tribunal is also excessive. Learned counsel appearing for the claimant submits that this is a case where because of the head injury sustained by him. The doctor had deposed that he has sustained 29.55%. 95 or 55?
55, my lord. 29.55.
55% disability. He submits that the court below, without any basis, had taken 10% disability. He had relied on the judgment of
Supreme Court, my lord.
that you are saying that without any
Judgment of
evidence.
court, our own High Court 2016 AAC 2344.
Party's name,
MS Nagesh Rao versus the Managing Director, BMTC Bangalore.
submits that without there being any evidence to on record to disbelieve the evidence of the doctor, the court below or the court cannot disregard the evidence of the doctor. When it comes to the pain and suffering, he submits that because of the injuries sustained by him, he was not in a position to discharge his duties, and even for his day-to-day activities also, he is depending on someone. Granting only an amount of rupees 40,000 at the head of pain and suffering is not reasonable. He submits that for the loss of income during the later period, even as on the date of the examination before the court, even that day he was not in a position to work, as in such case, it has to be taken, the loss of income should be taken from the date of accident till the date of trial. Then on the towards loss of future earning, he submits that according to him, he is working as a tailor and earning 6,000. Court below, without any basis, had taken 4,000. And towards loss of amenities, only an amount of rupees 15,000 is granted. Then counsel submits that the compensation that was awarded by the tribunal is not reasonable. Having heard the learned counsels on either side, there is entire material on the court. First, coming to the contention of the insurance company, that there is discrepancy in the manner in which the accident had taken place in the police records and the medical records. The payment was first admitted in Government Hospital Chikbalapur. In that it is clearly mentioned as while fall from a two-wheeler while traveling, fall from a two-wheeler while traveling. After that, he was shifted to Nimhans Hospital. In that, it is shown as it is written as he was driving the two-wheeler and sustained the injuries. Then coming to the medical evidence, the police records, within 1.5 hours from the time of accident, the complaint was given to the police. In that complaint, it is clearly mentioned that he was traveling on a two-wheeler and it's a fall from the two-wheeler. Then the contention of the insurance company that in view of these disturbances with regard to the manner of the accident, as he was traveling and he was not having driving license and he was under the effect of alcohol, they have shown him as a pillion rider. The entire story that was put forth is a fabricated story, and they are not liable to pay the compensation. In the evidence of the doctor, it is clearly mentioned that right from childhood, he is physically challenged, as both his legs are not working. In that case, the argument of the learned counsel that he is driving the vehicle cannot be considered, considering the police records at the earliest point of time which was given, and the police and the medical records before the hospital where he was immediately admitted. This court has no hesitation. Believe the case of the complainant, of the claimant, and this court finds no force in the argument of the learned counsel for the insurance company, and the court below had rightly held that insurance company is liable to pay the compensation. Then coming to the quantum of compensation, But as per the evidence of the doctor, as per the evidence of the doctor, the petitioner, the claimant was suggestive of bilateral frontal lobe within brackets, bilateral dorsolateral prefrontal cortex, bracket close, and bilateral parietal lobe involvement, and consistent with the initial CT scan finding. His disability was assessed at 29.55% as per the Government of India guidelines and the NIMHANS guidelines. The court doctor has opined that the disabilities, especially the impaired working memory, visuospatial working memory, sex shifting, / concept formation and preservation, and visuospatial orientation will definitely come in the way of his effective functioning as a ladies' tailor or some other similar activity. In view of these disabilities, the claimant cannot work as a tailor and cannot do any other manual work. The insurance company in the cross-examination could not elicit anything from the to disbelieve the evidence of the doctor. In the light of the division bench judgment of this court, which the learned counsel is relying on the first draft, and there is no other evidence to disbelieve the evidence of the doctor, it has to be considered. Hence, in these facts, court is inclined to take 25% as a disability. Then towards the pain and suffering, considering the nature of injuries, the prolonged hospitalization, and the impact, the pain and suffering he had undergone, this court deems it appropriate to grant an amount of ₹1 lakh under the head of pain and suffering. Coming to loss of income during the treatment period, as he is a tailor, and the accident had taken place which year? In 2009.
Right.
We had 5,000 into 6 plus 6 months, it would come to 30,000. Then coming to loss of future earning, considering the disability at 25%, 5,000 into 12 into 16 to 25 by 100 is 2,40,000. Loss of amenities, court below had granted 15,000. Considering the injuries, this court is inclined to grant 25,000 towards legal expenses, towards transport, conveyance, and attendant charges. No amounts were granted. This court is inclined to grant 30,000. In the light of the law laid down in Megala of Megala, towards legal expenses 10,000. Altogether, the claimant is entitled for an amount of 5,15,000. Accordingly, the appeal of the insurance company is dismissed, and the appeal of the claimant is partly allowed by enhancing the compensation from 2,36,800 to 5,15,000. The enhanced amount will the claimant is entitled in interest at 6%, and the amount that is deposited by the insurance company shall be transmitted to the court below forthwith, along with the certified copy of the order. Next. Who appears for the Mr. Mahesh? Mahesh? Yes. What is the claim? 19 lakh. How much was granted? Lakh? Disability? As for the doctor, how much the court had taken? 1/6. First occupation, how much is the income? How much the court had taken? Please come to the quantum. Now the insurance company was liable. Para number? Yes. What is wrong in here? No, on the disability. Now, he said to a particular limb it is 50%. To the whole body, how much it should be?
Whole body is 30%.
How it is calculated to the whole body?
Whole body 16, whole body 30%.
Which injuries to which part?
Face. Loss of weightage.
Right eye.
Right.
Uh,
And fracture for also.
please come to the discussion on injury. Please read from issue number 2 so that the court can understand.
That's what it is. The people of the government here really speak with the government of. And the some days, so value of us. From really to total break components. Depend of products created. And all here and read information. And open the fifteen hole, but the active basic study was also done and treatment for basic reformation and 7 and 8 operations of the but the petition would not vacate the right way, and the rating was total loss and facial reduction and the task also done. Company had been the everyone gain of the practice between the repayment and deduction and operation was done on the same day, but the train of could not be stopped. and the petitioner was discharged from leave to scheduled way. Baba Eritrea paid the value for payment of rent high again, the petition has been submitted to discuss the police of other value. Who has stayed for the medical attended struggles before asking for petition for running the factory and another by manufacturing over the plants, paid by the or 40,000 per month due to the use of they will produce what the order the business I know. To move independently, pleasure perspective and the flow of the emotion is the great pain. If the injuries to great loss and fracture of organ, bone and also under maxillary bone, side and female, eye and the head. He gets the giddiness and breathing problem, suffer and this decrease in memory, cannot do this normal and retain work as about doing here. Therefore, the times probably that as compensation in the area depends and spoken about the governments has made for the treatment of right, he had been advised to take treatment at level cost. The petition had again here from the day by conducting the study. Have been given study of conducted of the factor of retina, intention, but the retina could not be flattened and the petitioner was discharged from legal to the lady. Father had stated that the treatment had taken treatment and the direction of the petitioner had local right way to be only and anything to the now many he wants to these efforts and he will not be able to make them. Have taken on the basis of visible disability, covered the petition with the having or body has refused to receive an invitation.
It refers to my 1 minute. What do you say about the disability? Why 30% should not be taken?
Yes, my lord, now I invite your lordship attention to evidence of CW1 and 2.
Yes.
My lord, CW2, admittedly, my lord, he is not a treated doctor.
Yes.
And in cross-examination, my lord, he has a thing that there is no definite formula as to the arrive at the whole body disability. That is in Kannada, I am just translating it in English. So that CW2, my lord, is a doctor who has stated that how he has arrived at the disability, he says that there is no fixed formula as such. Then CW1 also, my lord, is a thing. He also, my lord, doesn't give the regarding the disability, my lord, as to the his avocation is concerned. Lord, now I invite your lordship attention to, my lord, the cross-examination of PW1, the injured himself. Your lordship kindly have, my lord, cross-examination of PW1.
Yes. Yes.
Cross-examine. Now I am not doing any work. I do not remember on which date I signed on my affidavit evidence. It is true that the contents of my affidavit evidence are written as per my instructions. Already I retired as a director of a company. That company was belonging to myself and others. In order to show the said existence of the company, I have produced no document. Exhibit P11 is issued by my chartered accountant in order to show my salary as a director from the company, not produce any document before the court. But this is the state of affairs so far as my lord his income is concerned. This thing. Then liability, my lord, is concerned, my lord.
So income, he has produced the salary certificate.
P11, my lord, P11
Oh.
may kindly be looked into. P11 my lord, is not proved.
No, but the court held that it is 10,000. Now we cannot, as far as that is concerned, will not go.
That is a different aspect, my lord. I am just trying to canvass before lordship, my lord. Exhibit P11, which has been taken into consideration, because I am not in appeal, but what I am trying to submit, you know, it does not require any enhancement for that reason. Exhibit P11, my lord, is says that 1,40,000 per annum. P11 may kindly be looked into.
No, under the Workman Compensation Act, if a person loses one eye, what would be the disability?
Lord, here you are kindly see, he is not a workman. And
No,
here,
I'm just asking.
yes, my
But
lord,
there's-
yes, my lord. For that, my lord, the doctor has to, if that is so, my lord, if that has to be taken into consideration under the Workmen's Compensation Act, 50% of the income has to be reduced. The formula, my lord, which is there, if we go by the schedule, suppose if the calculation is that 50% loss of earning capacity, if he's earning 10,000, then it will only 5,000 will be taken into consideration. That's why we can't equate that formula into the, my lord, a third party claim. Therefore, here I have read, my lord, the evidence of, my lord, cross-examination of, my lord, the claimant. He says that he has no document. He says he is a director. He says, my lord, exhibit P11 may kindly be looked into. That is, my lord, says 1,40,000 per annum. Filing an income tax return itself is not a, my lord, proof of income. Assessment order has to be produced. I can, my lord, file a return saying that I am having 1 crore per month. But it has to be supported and an assessment order has to be done by the competent authority, income tax department. Therefore, my lord, the court has taken it as 1,20,000 and thereby 16% disability. You will have to kindly see the nature of the work, my lord, what he was doing. Though he claimed that he is not doing it, but he has admitted that he has no document to show. Therefore, only for injury, pain and suffering he is entitled, for which, my lord, 1,50,000 has been given. Medical expenses 2,50,000. And however, future loss of earning has been, my lord, granted 2,49,600. And loss of amenities of life 1 lakh. So therefore, totally 8,54,600 has been allowed. And it's a accident of 2007. Though we are dealing the appeal, my lord, in 2023, we have to go back in the time machine to 2007 and assess the, my lord, the material on record. There is no positive evidence to show that because of this injury, the loss of earning capacity has come down. All injuries will not lead to loss of earning capacity.
It's the loss of vision. It will have impact on all
Definitely.
walks of life.
Yeah, but that's why, my lord, I said, for injury, pain and suffering is entitled to, not for loss of earning capacity, which has been granted by the tribunal, which you have not challenged. And doctors examined, my lord, does not give, and they say that there is no specific formula to arrive at the body, whole body disability. Two doctors have been examined as CW1 and CW2. What is the nature of, my lord, his work as a director? Nothing has been spelled out. Nothing has been produced. Nothing has been proved in respect thereof. For loss of time, injury, pain, and suffering is entitled. Absolutely, there is no evidence as to the, because of this disability, his loss of earning capacity has reduced. If so, to what extent? In cross-examination, he has admitted he has not produced any document except Exhibit P11.
Still expensive, what do you say? No, do you dispute that? What is the multiplier?
He was aged 43.
47.
Held age is 47. Thirteen multiplier could be
If the disability is taken at 25%,
Lord,
into-
there is no, my lord, this thing, doctors, my lord, have not given anything. They say that there is no,
he lost his eye, one eye, that is, it will have impact on the whole body.
Lord,
His age is 43,
Lord, injury,
47.
there should be evidence that injury has substantially reduced his earning capacity. Therefore, my lord, my submission is for injury, pain and suffering is entitled to, I have no thing, my lord, dispute about that. Whether that injury has reduced his earning capacity in any way. For that, there
It's
should
not
be,
like it is to other parts of the body. It is to the eye. That for that, we don't require any other evidence.
if
It will
for,
have impact when it is, you can only see half of it. It
right,
will have impact.
if that is the opinion of the court, my lord, I have no say.
Yes. It comes to 12,20,000. Other things as it is remain, only as far as loss of earning due to disability is concerned, court had taken at 25%, same 10,000. Other things remains to be the same. Okay. This is an appeal filed by the claimant, agreed with award passed in MBC number 336 of 2009, dated 28 May 2012. The claim petition is filed seeking compensation of an amount of rupees 90 lakh for the injuries sustained by the claimant in the accident, and the tribunal had awarded an amount of rupees 8,54,600. The case of the claimant is that on 17/12/2007, at about 7:30 p.m., the petitioner was traveling in a Maruti car driven by respondent number 1 from Bangalore to Mantralaya. Because of the rash and negligent driving of the driver of the car, that it dashed to one bullock cart, which was moving in front of the car, as a blazing red crashed from the opposite vehicle. The driver of the car had lost control, dashed to the bullock cart. Due to the impact, the petitioner had sustained bleeding injuries over his head, face, eyes, jaw, hands, and on all other parts of his body. Immediately after the accident, he had been taken to Government Adoni Hospital, Andhra Pradesh, after first aid, and on the advice of the doctor, he had been shifted to the Government Hospital, Kannur, and thereafter to the Bangalore Hospital, and was treated as inpatient from 18/12/2007 to 25/12/2007. The petitioner had undergone operation to his right eye, but could not retain the right eye, and the right eye he has lost vision in the right eye, and facial reduction and plastic surgery was done to his face. He was admitted to Retina Institute of Karnataka as inpatient on 7/1/2008 for fracture of retina detachment, and operation was done on 7/1/2008. And the retina could not be flattened and was discharged on 8/1/2008. Further, he had taken treatment at Prabha High Hospital, Jayanagar, and at Vitala Institute of Ophthalmology, Padmanabhanagar, Bangalore, and spent an amount of rupees 6 lakh for his medical and attendant charges. The quote below, it is the payment that is earning an amount of rupees 40,000 per month. The quote below has considered exhibit
P11,
P11, which is an income tax return, the salary certificate, and take and consider the salary at rupees 10,000 per month. When it comes to the disability, the doctor had given the evidence that which para? The petitioner is getting it is the doctor that on the basis of visible disability chart WHO, the petitioner is having 30% disability to the whole body. The code below had considered the disability as he has taken 15% to a particular limb. The court had taken the whole body at 16.6%. Has taken 16%. For the loss of income due to disability, had granted an amount of rupees 2,49,600, 1,50,000 towards pain and suffering, towards medical bills 2,37,924. That is 2,50,000 towards medical expenses, 25,000 towards loss of earning during the treatment period, the 2.5 months, and 50,000 towards food, diet, transport, and attendant charges. Further, towards future medical expenses, 30,000, and towards loss of amenities, 1 lakh. In all, granted compensation of an amount of rupees 8,54,600. When counsel appearing for the appellant submits that when he has lost the vision of one eye, and then the doctor has deposed that it is a 30% disability to the whole body, the court by applying, considering the disability, as it is stated by the doctor that is 50% disability to a particular limb, had taken 1/3 and only considered 16% as a disability. Land counsel submits that when the petitioner has lost one eye and when it is a major organ in a body, and the court below went wrong in taking only 16% as disability. He submits that even under the head of loss of earning, when he had to undergo several treatments and he was going around hospital, court under the head of loss of earning due to disability had considered only 2.5 months. He submits that for the injuries sustained by him, the compensation that was awarded was not reasonable. Land counsel appearing for the insurance company submits that the court below without any basis had considered the income as 10,000. It is submitted that absolutely there is no evidence. When coming to the doctor's evidence, land counsel submits that according to the doctor, the 30% disability to the whole body. On what basis he had come to such conclusion? There was no explanation forthcoming in his evidence.
In the cross-examination also, he has admitted he has no document.
In the cross-examination also, he admitted that there is no document for that. It is submitted that and further the doctor had to say, because of this disability, what would be the impact of it on his future earning? That particular aspect, that explanation is silent in the evidence of the doctor. And when there is no such evidence, the court cannot consider that there is a loss of future earning capacity, and under the said head, he is not entitled for any amount. He submits that the tribunal already granted the compensation on a higher side, and it do not require, and no grounds are made out by the claimant seeking enhancement of the compensation. Next paragraph, having heard the counsels on either side, there is entire material on the top. From the admitted facts in this case is that because of the injuries sustained by the claimant, he had lost one eye. Doctor's evidence based on the WHO guidelines. It is 30% disability to the whole body. It is a case of the counsel for the insurance company that whether the loss of every injury, every disability would not lead to loss of future earning capacity. And according to him, the doctor had not given a evidence on that, and there are no parameters. The submission, the court is not able to appreciate for the reason the claimant had lost one eye, and which is a major organ of the body. Though there is no specific evidence for any person for any activity, loss of one eye would have an impact on the future earnings. But the doctor had stated that for the whole body, as per the WHO guidelines, is 30%, code below, considering 50%, and from that, considering 1/3 of it, had taken only 16%. Under these circumstances, the court is inclined to take 25% as a disability. The counsel for the insurance company has argued on the income as this is an appeal of the claimant, and no appeal is preferred by the insurance company. This court is not inclined to go into the said aspect. Hence, on the head of loss of future earnings due to disability, considering at 25%, it would come to 3,90,000. That is 10,000 into 12 into 13 into 25 by 100. Loss of vision, the loss of vision code below had granted 2 lakhs, pain and suffering 1,50,000, and loss of and attendant extra nourishment 50,000, future medical bills 30, loss of amenities 1 lakh, medical expenses 2,50,000. This court do not find any reasons to interfere with the said finding. When it comes to loss of earning during the later period, considering the court had granted only 25,000, considering the treatment he had taken, and for all for the time it takes for him to resume work, this court is inclined to consider 4 months' income for the loss of earning during the later period. It comes to 40,000. And in the light of the law laid on insurances and to legal expenses 10,000. Altogether, it comes to 12,20,000. Accordingly, appeal is allowed by enhancing the compensation from 8,54,600 to 10,20,000. The enhanced amount will carry percentage.
No interest on the future medical expenses.
No interest on the future medical expenses. That is that. Yes.
Number 10, any questions, Swami?
Who appeals for the respondent? You are on liability? Huh? Implication of the rate. How much is the claimed amount? How much is granted? How much? 790. Case of injuries. Which para, let's see. Let's see issue number 1. Please read. Sir, on implicants of the vehicle, where is the Hmm. The vehicle number is KA 5252-2232. Let's look at your ground. What did you raise? First is there was a delay of 3 days in giving the complaint. That is the first ground. Complaint it is stated as KA 02 EQ 5381 and the said vehicle dash against the as to how we can change the vehicle number and the termination purpose. The tribunal was further required to have noticed the contents of the complaint reversed follows. This is for law. What is the investigating officer has not even bothered to exercise. Now, what is the relationship between the insured and the claimant? We'll take up tomorrow. Ask the senior to come tomorrow. The request of non-counsel for the appellant. Next matter.
Number 11.
No representation for both. You appear for the respondent.
Yes, my lord, the copy is not been served, my lord.
No representation for the respondent. Post for dismissal thereafter.
Copy is not served, my lord, on me.
It is submitted with the non-counsel for the respondent that copy of the appeal memo is not served. Yes, next.
Number 12. N. Vishwanatha.
Ready? The cause title shows your name. Mr. Swami for R1. After the request of learned counsel for the respondent. Next. Both of you are ready? Yes. Trans claim, how much was granted? See? Oh, the insurance company's liability is that. Oh. Now, what are the, any disability? How much the court had taken? No disability was considered. What was the income? Boy, minor boy. Let's see where the liability of the insurance company is discussed. Which para? Internal page number? No. Oh. Srinivas is the insured. This person is a pillion rider. Huh? He was standing on the road. Oh.
Guardian of people. Rider is also demonstrated. Was not as police.
What is this finding about the?
We want to doesn't have driving license. Therefore, the implicated the classified rider not driving. No computer in that in the process of not only for not driving the motorcycle. The hospital is also You will aware of it.
So, no, what is the evidence that this Srinivas has no driving license?
He was a court.
What is the evidence?
But he was no driving license since he implicated Subhash Chandra.
No. Let's forget about this implication. Who was driving the vehicle as per the complaint, as per the FIR, as per the charge sheet? Subhash Chandra is driving the car. And 1 minute. And whether the Subhash Chandra is having a driving license or not. He is having. Then where was the basis for the court to come to a conclusion that Srinivas is driving the vehicle and he has no driving license and you are not liable? That was not the reason for them to consider.
During the course of cross-examination, the PW1, he himself has admitted that when Srinivas was the rider as on the date of accident. He only told that this is the vehicle number I am ready. On that basis,
Is it in Kannada or in English? PW1 evidence. Give the evidence. Let's take the cross examination. The rider of the motorcycle by name Srinivas was also present. No, owner of the vehicle is Subhash Chandra. Is it not? Owner of the vehicle is Subhash Chandra. Driver of the vehicle is Srinivas. Now, that Srinivas has no valid driving license, where is the evidence for that?
The question to me, PW1, who doesn't have a driving license, that's why he had implicated Subhash Chandra.
He didn't say so. In the evidence, he didn't say so.
All evidence, written evidence.
No, he's cross-examined.
PW's cross-examination.
You have not posed such a question. You have not posed such a question. You have not posed such a question. Huh?
Was one Srinivasa was the rider.
Rider of the vehicle.
He has informed,
Implication and all, no. When, if you see, there was no difficulty on my part to file the complaint before the police. I informed the name of Srinivas that he has dashed a motorcycle to my son's petitioner. I do not know whether Srinivas is holding driving license to ride the motorcycle. It is not true to suggest that by colluding with the police, I have fixed a motorcycle belonging to Subhash Chandra Sharma and filed charge sheet against him. Because being the owner of the vehicle, owner and the driver might have not been
Srinivasa is in the picture. If the owner of the vehicle is there, then who would have produced the driving license?
Let us see the complaint. What did this say in the complaint? Who is PW? Who is the doctor? Next PW3 is RW1. I said that I'm working as a legal. Srinivasa holding driving, the said Srinivas holding license as a vehicle. The petitioner was implicated that either Consul Chandra. Whose case is that? Where from the Subhash Chandra has come?
And they requested the vehicle to me. And they have driving license.
Yes.
Therefore,
So where is that? Where is that? Now you also
we have
say.
rendered evidence on that case.
Then in that case, what should follow?
They said that Srinivas doesn't have a driving license. That's why
Mere saying it is not sufficient.
Last examination admits that 3 months also right.
Yes. So now the issue that has to be decided is whether Srinivasan was having a driving license or not. No positive evidence is reckoned by you to show that there is no license. In that case, when you have failed to discharge your burden, stay and record. And what about the enhancement? Sarah? Hmm. Are you reading the para number 10? No, let us understand. The sustained fracture of both bones of right leg. Fixed.
I'm giving the version of the PW2 and PW1 of the good certificate. It doesn't go source the bone fracture without sustained. That's why we are in the but in the evidence of the doctor, it is showing that bone fracture has been suffered. They are not putting the X-ray to show that they are considered bone fracture. That way, you know that we will register the version of the and awarded a compensation of 50.
He has also not examined the doctor of the site hospital to show that he was treated as inpatient.
So that we are sustained.
Then what basis you will have compensation?
Sometimes we don't want to be on camera for our Zoom calls, but we do want a profile picture of our face or anything else. I'm going to show you in this Zoom tutorial how to change your profile picture or add a profile picture.
Even 20,000 also without any evidence. We'll add another 10,000 legal expenses. Please come. This is an appeal filed by the claimant. Unfortunately, you are not adused already. If, the court cannot do that much of guesswork. No, your wound certificate does not contain the injury. Then the doctor says about the practice and all. For that, no X-rays, nothing has been placed on the record. How to? Huh? That is disability certificate. Okay, for arriving at a disability, there should be a basic clinically, the X-rays and other things. Without that, just like that, the doctor's evidence can't be considered. What you will get now, happily, no, what will happen is, happily enjoy the interest that you get from that time to now.
It may be derived. We know now, we know they are not at all. No, Indian fellowship is going to order paid recovery. It's also my it's not happening.
Is an appeal filed with a particular filed with a claimant agreed by the award passed on number 5434 of 2010 dated 21st January 2012. The claim petition is filed in compensation of an amount of 6 lakhs for injuries sustained with the claimant in the accident. The court below had awarded an amount of 50, granted an amount of 53,000 and held that only the owner of the vehicle is liable to pay the compensation and exonerated the insurance company from the liability. The court below, while coming to such conclusion, has observed that the PW1 in his cross-examination admitted that once Srinivas was riding the motorcycle, and Srinivas informed about the number of the motorcycle to the authorities of Manipal Polyclinic Nursing Home, and there was no difficulty on his part to file complaint for the police soon after the occurrence of the accident. The admission of PW1 indicates that after a delay of 27 days, he has filed a complaint before the police by colluding with the police. Charge sheet came to be filed against his accused by name Subhash Chandra Sharma, son of Ramesh Dayal Sharma, who on Srinivas was riding a motorcycle at the time of occurrence of the accident. The court observed that as Srinivasan was not having a valid driving license, the petitioner had implicated Subhash Chandra Sharma. And it also indicates that the petitioner and the respondent number 2, owner of the vehicle, by colluding with each other, have implicated one Subhash Chandra Sharma in criminal case who was having a driving license, despite of implicating Srinivas, who was riding a motorcycle at the time of occurrence of the accident. Hence, the court held that the respondent number 2 alone is liable to pay the compensation. Respondent number 1 is not liable to pay the compensation. Who is this Abhishek Chaudhary? Another name. That is the owner of the motorcycle. And where is this Subhash Chandra Sharma has come into picture? That's right. But entire judgment court was in that case, how can the court say the him also liable when the court says that somebody else vehicle is that? Right, Abhishek Chaudhary, wherever that Subhash Chandra.
This is the rider. Subhash Chandra is saying that this is the rider, charged rider. Abhishek Chaudhary is the owner of the.
The evidence of PW1 is that that once Srinivas is riding the vehicle, if the court had come to the conclusion that the Srinivas has no valid driving license, there should be some material in support of that. The insurance company, except taking a plea that Srinivas is having as not having a driving license, no evidence is written. The court below, without there being any basis, have held that the insurance company is not liable to pay the compensation. When the accident had happened, and according to them, when Srinivas is riding the vehicle, if he is not having a driving license, it is for the insurance company to adduce the evidence. At best, if there is no driving license, the insurance company, any insurance company is liable to pay the compensation and record the same from the owner of the vehicle, as the claimant is a third party to the insurance policy. The insurance company's liability cannot be denied. You have the same. The court finds that the insurance company is liable to pay that compensation and record the same from the owner of the vehicle. When it comes to the compensation, then comes for the payment as there several grounds stating that the just and reasonable compensation is not granted by the tribunal. This court has perused the entire material. The payment has failed to adduce the proper evidence in support of the injuries sustained, as the wound certificate itself does not disclose about the injuries sustained by him, the fracture injuries sustained by him. Though disability certificate is filed, he has not, the doctor on what basis has come to such conclusion. The X-rays, nothing or not, as the court below had rightly granted an amount of rupees 50,000, 30,000 towards pain and suffering, and an amount of rupees 20,000 to be towards medical expenses and rupees 3,000 towards transportation charges. Both files shown them to interfere with the same, accepting the law made known in Mekala, they're entitled for 10,000 towards legal expenses. Accordingly, appeal is allowed, partly allowed, by enhancing the compensation from 53,000, 63,000. The compensation amount will be paid by the insurance company. As per the same from the owner of the vehicle. Yes, thank you. Yes. Yes, Mr. Mahesh is there. Is this why? Let's read the. Okay. He was No, when you sustain those many injuries on 30th, What were you doing till first to admit in the hospital? As per one thing, you were admitted on 30th, discharged on 1st. You say that you were admitted on 1st, discharged on 20th of that month. It's not about PW1, it's about the evidence. Let's see that evidence. No, I'll tell you that. Exhibit P8 discloses that petitioner was admitted on 30/5/2010 and discharged on 31/5/2010. Whereas petitioner here has stated that he has taken treatment in the hospital on, that is your consistent case about 1/6/2010 and has discharged on 26/2010. Take the evidence of PW1. Is it in English or please give the evidence? Let's see. No, read from paragraph 3. I say that on 35/2010. This exhibit P8 is by Netaji Hospital. Exhibit P8.
I have stated was patient was
You gave the complaint after how many days? Police complaint?
even you for that. There are please, the complaint was according to.
No, let's go to the cross examination. What did you say? Please read the relevant. Yes. Admission in the hospital. Read. Yes, Mr. Mahesh, what do you say on that about the observation in the judgment saying that on according to as per the medical record, he was admitted on 35 and on for 1/6 he was discharged. But whereas his evidence is that he was admitted on 1/6 and discharged on 26. Please unmute your audio.
Mahesh, sir.
That has been discussed in para 11 and 10 and 11 of the judgment.
Correct. Where is that evidence of PW1? Can you find out from point out from the evidence? It is not stated so, according to him.
Well, it's a certified copy of this thing. What has been stated on by him is the record on record.
That's why you read it, it is not here. According to him, it is not there in the evidence. It is a wrong appreciation of that. Please point out from the evidence.
Yes, I'll read para 3 of his examination in chief.
Cross-examination or examination?
Cross-examination is in Kannada, regional language.
Oh.
That is not legible. Now, para 3 of the examination in chief. I say that on 30/5/2010, at about 1 p.m., I was proceeding as a rider in my motorcycle bearing registration number KA19V 4807 from Kumpala side towards Mangalore side.
To come to the end of that para. Other things are not relevant. End of that para, third para.
Yes.
I was inpatient in Netaji Yellappa Memorial Charitable Hospital,
Yes.
Mangalore from 2010 to 1/6/2010.
Immediately I was shifted to name. Milord, may I read, Milord?
No, only that date is important. In the entire evidence, chief affidavit, he has not stated.
Immediately I was shifted where doctor. That has to be read in whole, not in isolation. You will have to kindly see, Milord, the last few lines. I was inpatient in Netaji Yellappa Memorial Charitable Hospital, Mangalore, from 30th of May 2010 to 1/6/2010. I was discharged from the said hospital with an advice to come for the follow-up treatment and to take bed rest at home. I say that during the period of my hospitalization, I had engaged one Mr. Santosh to look after me, and I was paying him rupees 150 so and so. That you will kindly see now. I'll take your lordship through the reasoning of the traveler in para 10, my lord.
Yes.
As seen from the wound certificate exhibit P3, the petitioner had sustained laceration measuring 5 centimeters by 3 centimeters and by bone deep, obliquely placed over the left side of the head, temporal area. Abrasion measuring 4 centimeters by 3 centimeters over the right cheek. Abraded contusion measuring 3 centimeters by 3 centimeters over the nose, and tenderness swelling over the left side of the face. And all the injuries are stated to be simple in nature. Though the accident has occurred on 30/5/2010 at about 1 p.m., the petitioner has lodged the complaint on 1/6/2010 at about 6:15 p.m. That is, after 2 days of the accident. The wound certificate also discloses that the petitioner is admitted to the hospital on 1/6/2010 at about 7:30 p.m. That is, after lodging the complaint and has taken the treatment. In the complaint exhibit P2, he has stated that soon after the accident, the people gathered there, and Avinash, who has been examined as PW4, was also present at the accident spot, took him to Netaji Yellappa Memorial Charitable Hospital, and he was treated as inpatient in the said hospital. If really he was treated as inpatient soon after the accident, he would have got admitted to the hospital on 30/5/2000 itself. That is the date of accident. Whereas PW3 discloses that the petitioner has taken treatment on 1/6/2010. The petitioner has got summoned the admission record from Netaji A. Yellappa Memorial Charitable Hospital which is not marked in evidence. However, admission record discloses that the petitioner was admitted to the hospital on 1/6/2010 at about 7:30 p.m. and was discharged on 26/2010. The history of causing the injury is not shown in the case sheet. The petitioner has produced the medical bills. Exhibit P8 to 10. P8 is the discharge bill, which discloses that the petitioner was admitted as inpatient on 30/5/2010 and discharged on 31/5/2010. And bill amount shown as rupees 1,530. In the inpatient case sheet, there is a bill which appears to be the discharge bill, which is only for a sum of rupees 905, except for the amount exhibit P8 and the bill found in the case sheet. The particulars of the bill remain the same. Admission charge rupees 50, room rent is shown as 150 in case of the sheet in case sheet bill, whereas the exhibit P8 room rent is shown as 250, service charges is shown as 25 in case of case sheet bill, but in exhibit P8 it is shown as rupees 30. In exhibit P8 MLT, a charge is shown as rupees 300, X-ray charges rupees 130, and suture material charges is shown as 7,050. Whereas in case of case sheet, bill shown is rupees 250. The difference between the two bills is more than 600. And this is also goes to show that the hospital record are created for the purpose of claiming compensation, and the bills produced by him are not the actual expenses incurred by him. PW4 was deposed that petitioner was taken to the hospital on the same day, and exhibit P8 also discloses that the petitioner was admitted on 30/5/2010 and discharged on 31/5/2010. Whereas the petitioner has stated that he was taken treatment from the hospital on 1/6/2010 and was discharged on 26/2010. Hence, the evidence of the petitioner is inconsistent with the hospital record and create doubt with regard to the very nature of the accident and the injuries sustained by him in the accident. Para 11. The petitioner has produced the spot measure as exhibit P6 and sketch exhibit P7, which discloses that the national highway from Mangalore to Kasaragod runs north to south. Kumpala crossroad.
Continue tomorrow, Mr. Mahesh.
Yes.
The leave of the court, man. Serial number 18, my lord. Day after tomorrow, man. 1 day accommodation.
Yes, serial number
18, my lord. 18.
I am for appellant, my lord.
Day after tomorrow, I have gotten.
Start. ಏನ್ ಪೇರ್ ಸ್ವಲ್ಪ ಬಿಲ್ಜ ಸ್ವಲ್ಪ ಅಲ್ಲ ಇಳಿದೋದ್ರು ಅವರು ಸಾಹೇಬ್ರ
ಹಲೋ ಹೇಳಿ ಸರ್. ಎಸ್ ಸರ್.
Serial number 18, I am mate, ma.
Serial number 18, day after tomorrow, sir.
Day after tomorrow, Saturday,
Day after, ನಾಳೆ ಎಲ್ಲ ನಾಡ್ದು.
Friday.
22nd, sir.
22nd.
ಅವ್ನು ಸೆಂಟ್ರಲ್ ಗುರುಸ್ವಾಮಿ ವೆಂಡರ್. ಅವ್ನು ತಗೊಂಡು
Court officer,
ಎಸ್ ಸರ್.
serial number 21 and 25, madam.
ಸರ್ ನಾಳೆಗೆ ಸರ್.
ನಾಳೆಗೆ
Tomorrow.
21.
ಹೌದು. ಎಸ್ ಸರ್.